Okay, so welcome to our civil procedure class. Last time we started discussion of trial. So we propose to first of all continue and complete. And then we will start other areas, including enforcements of judgments and then appeals before we end tonight's session. So if you look at our syllabus, with respect to trial, we are expected to develop the following competencies: the ability to appreciate how proceedings are conducted during trials of civil actions, understand the consequences of absence of parties at the trial, understand how evidence is adduced in civil proceedings, understand the rules of examination in chief, cross-examination, and re-examination, understand judicial management of the trial process. So these are the matters which are expected of us. Of course, we will notice that because we are learning law of evidence, and a good chunk of the things which are also needed here are already taken care of in the law of evidence. And for that matter, we will not belabor the point because you have already covered them. Because we have already covered them, we are building on the platform of that acquired knowledge and appreciation so far. Now, that said, when we talk about trial, we have to remember that it occupies the very heart of civil litigation because it is the stage where the dispute between the parties is resolved through presentation of evidence and evaluation of evidence. The parties will have to present the evidence, and then the court will have to evaluate the evidence. Which of the evidence, as we know, using the civil standard of proof, preponderance or probabilities. In other words, whose case is more probable to be the truth as opposed to the other. And then the court will use that to do its judgment. And in talking about trial, it is pertinent to remember the fundamental principles of natural justice, particularly odi oteran partem, that both parties be given opportunity to present their respective cases before the court. And that is very important. So, in a trial, is the stage where the parties confront each other's claim, witnesses testify, documentary evidence where available is tendered, and then legal submissions in the form of written addresses or oral addresses, as the case may be, are urged on the court by lawyers of the parties. And the court ultimately will make a determination as to the rights and liabilities of the parties. So basically, that is what the trial is supposed to be. And in terms of like the place and mode of the trial, we noted last time that as a general rule, trial is supposed to be conducted in the public because the court is for everyone, and unless exceptions are created for maybe either extreme privacy concerns, like maybe when it comes to matrimonial matters, because of the sensitive nature of the evidence, sometimes even vulgarity, as the case may be, you do not want that to come in the open. And then when it comes to matters relating to children, we also need to protect identity of the child. So for good reasons, it may not be done in public, but it may be done in the judges' chambers. Yes, otherwise, if you look at order 1, 2, at the end of the CI 47, we have noted already that proceedings of every court shall be held in the public. And it's consistent with what the Constitution says in Article 126, clause 3. And of course, public trials or openness in the trial ensure transparency of judicial proceedings. Also ensure, please, let me lock your mic. Some of you
on social media.
Oh, please. Learn this discipline when you're doing online meeting. The first thing you should pay attention to is when you log in, immediately check to ensure that your mic and your videos are switched off. Otherwise, you may be sharing information and scenes which you do not intend to share with third parties. All right, thank you. Yeah, so public trials ensure transparency of judicial proceedings. It also ensure public confidence in the administration of justice because people begin to see that trial, adjudication is not shrouded in secrecy. Everything is in open. Everybody says it. And for that matter, at the end of the day, when verdict is rendered by the court, people are able to take it as fair, as it were. But of course, I have noted, told you that under the Matrimonial Causes Act 1971, Act 367, proceedings may be held in chambers. We've explained that. And also, if you look at the Cause Act, Section 102 of Act 459, it makes the point that in the interest of public morality, public safety, defense, protection of minors, and protection of private lives of persons involved in the proceedings, the court may exercise a discretion and restrict publicity, as it were. Good. When we were learning about the case management, we talk about setting actions down for trial. Setting action down for trial. That is, after pleadings have closed, directions have been taken. The case must be prepared for trial, and under the modern case management regime made possible by CI 87, you look at the CI 87, the parties will have been ordered to file their witness statements. And once they file their witness statements and pre-trial checklists, the court will then be seized of matters which are supposed to be used for the trial. We've discussed witness statements already, so I do not intend to belabor it. Suffice to say that if you look at it at 38 with 3B, it would remind us that the parties should serve witness statements reflecting what they intend to rely on during the trial. So instead of you waiting during the trial to come and make a long or lengthy narrative, it's supposed to be reduced into writing. We've learned how the witness statement is crafted, so we are not going to belabor the point. Suffice to remind ourselves that the witness statement constitute the evidence in chief of the witness eventually when the trial begins. And for that matter, it must contain only admissible evidence. So that when you are crafting a witness statement, remember that if the person was standing in the witness box and then the person was saying the things that you are writing, would the law relating to admissibility of evidence have permitted that to be received? If the answer is no, then don't include it in the witness statement. The third point is that the witness statement must be consistent with the pleadings. We have learned already that the pleadings provide the framework of the controversy, the allegations of fact grounding the controversy. So the witness statement is supposed to flesh it up. So the witness statement should not be unrelated. You should be able to link your witness statement to the pleadings. Otherwise, the rule against departure and so on. And again, witness statement must be verified by statement of truth. So as we learn the drafting, after everything, there must be a statement of truth that the person is affirming that what he has said is what is true. And again, where the person is illiterate, then the Illiterate Protection Ordinance, Cap 2 says to requires that a jurat will have to be included. And again, we also noted that the witness statement should be accompanied by all exhibits the party intends to rely on. So therefore, if you were standing in the witness box giving your evidence in chief, and you have, for example, referred to certain documents or certain items as supporting the story that you are narrating before the court, that will have to be reflected in the witness statements. And then we talk about pre-trial checklist, so we'll not go through that again. So once everything is done, the case management is done, the court sets the action down for trial. And when the court sets the action down for trial, what it means is that the case is ready for trial to begin. All the pre-trial things which we'll be talking about after the issuing of the writ, from pleadings, interrogatories, requests for further and better particulars, discoveries, inspection, notice to admit, all those things, they are all directed towards one destination. And that destination is the day of the trial. So once all those things have been done, everything is set for the trial. So if you look at Order 36, we discussed it the other day with respect to the obligation to attend a trial. Of course, the parties and their lawyers, or what you call counsel. Please don't say counsels, okay? Don't add s to the word counsel. That is bad legal English. Counsel is like ship, just as we don't add s to ship. So don't add s to counsel. Even if they're 100, they're still counsel. Good. So if you look at Order 36, it provides what should happen, the consequences, that if the case is called for trial and all the parties fail to attend, the trial judge may strike the action of the trial list. So there's what we call the cause list before the court. So the case is called, no party is present, no lawyer is present. The judge has the discretion to strike the case off. Of course, he may also decide not to strike the case off. He may decide to adjourn the case sine die, or as some people will say, sine die. When the case is adjourned sine die or sine die, what it simply means is that it's not adjourned to any particular date. So it's in abeyance. Whenever anybody is ready, the person can take the step to have the registrar to fix the case for hearing. So that is how it is. So, but where the plaintiff is present and then the defendant is absent, the court may dismiss the counterclaim if the defendant had a counterclaim and allow the plaintiff to prove his case, his claim. Now, the other scenario where the defendant is present but the plaintiff is absent, the court may dismiss the case of the plaintiff. And if the defendant has no counterclaim, allow the defendant to prove his counterclaim as the case may be. But the law, Order 36, Rule 1, Sub-Rule 1, Paragraph 6C, also give a broad latitude or discretion to the court regarding what the court may do in the situation of absence of the parties or their lawyers or one of them. And that is why it says that the court may make such other order as is just. So the court may have regard to the circumstances of the case and make appropriate orders. But what the court should always do is that since you are called with a discretion, if you exercise a discretion, it should be transparent. Transparent in the sense that you must provide the reason or the basis why you are doing it this way and not that way, so that if anybody reads your judgment or ruling, the person will understand why you exercise the discretion in a particular way. And if you don't do that and somebody makes an appeal, it's very easy for an appellate court to reverse because you didn't exercise the discretion judicially or judiciously. You didn't provide reasons, as it were. Now, where a judgment has been given in absence of a party, and this is very important because it's a very simple rule, but because we don't read it, a lot of practitioners often are caught by it. So where the judgment is given in absence of a party, let's say that the plaintiff was absent and the defendant was allowed to prove his counterclaim, judgment is given, or the other way around, the affected party has a period of 14 days after the trial to bring an application to have the judgment entered in its absence to be set aside or varied, as the case may be. So there's a timeline. It's 14 days after the trial. And if you don't come within 14 days after the trial, you lose your right to have it set aside. So let's pay attention to that. And we've also touched on the adjournment and delays. So the rules provide for what should be done. And so the 36 Rule 3 makes the point that the court may, if it considers necessary in the interest of justice, adjourn a trial for such time to such place and upon such terms as it considers fit. So where it's necessary, and here, adjournment does not necessarily mean that the parties are absent. No. For whatever reason, if the court considers it necessary in the interest of justice, it may well be that certain orders have been made by the court. Or maybe, for example, when it comes to land litigation, it may well be that a composite plan has been ordered for the court-appointed surveyor to prepare it, and it's not ready. And then the judge says that, well, I want everything to be ready before I start the trial. So the court may, for example, want to adjourn it. So all those things are there. Sometimes your party may also request for adjournment, but then if you request for the adjournment, it's for the court to decide whether it will grant it or not. And that is why in a case like Ali Yusuf, Issa number 2 against Republic number 2, 2003-2004, One Supreme Court of Ghana Law Report 174, the Supreme Court reminded us that adjournments were within the sole discretion of the court, and the mere refusal by the trial judge to grant the appellant's application for adjournment could not of itself constitute a denial of the right to fair trial. So meaning that it is the court that will determine whether it should adjourn or should not adjourn. And this is very important. In practice, we have a situation where a junior lawyer is sent by the senior to go and hold brief. And the junior might have been told just to go and take a date. And you go and then the court will say that, well, I'm ready to continue with the trial. Counsel, continue the cross-examination. And then counsel will be insisting that my instruction is to take a date. The court will say, continue the cross-examination. The court is right because the power to adjourn is a discretion. So it's not for you, a party, to say that I want the matter to be adjourned. And that is why if you're a lawyer, you're going to court, you must know the business for the day and prepare yourself. And don't think that I'm just going to take a date. It doesn't work that way. So look at also the case of Republic against High Court Fast Track Division, S party, Cien Goldfields, S party, Cien Goldfields. S party, Cien Goldfields is the 2009 SCGLR 204. The Supreme Court made the point that a court is not bound to adjourn a case merely because a counsel has written requesting an adjournment. So in practice, letters will be sent to the court through the registry. The lawyer saying that due to XYZ, the court will adjourn. No. Those letters, I'll treat them as the courtesy letters, but they are not the letters which are as of right, in the sense that because you've sent the letter, then the court should adjourn. No. The judge will have to have regard to whatever is necessary and make appropriate decision regarding the direction where the judge's pendulum of discretion should swing towards, as it were. Now, it's also possible for the court to strike the case out for want of prosecution. And that is why Order 37 is important. Order 37 speaks to adjournments and delays. And for example, if you look at Rule 4, 37, Rule 4, where in any cause or matter, no step has been taken for 12 months from the date of the last proceeding, and no notice under Rule 3 has been given, the registrar or any party to the cause or matter may apply to the court for an order that the cause or matter be strike out for want of prosecution. And the notice of application shall be served on all parties concerned at least 14 days before the day stated in the notice for hearing. And upon hearing of the application, where none of the parties show cause to the satisfaction of the cause, why the cause or matter should not be strike out, and upon proof of service of notice on all parties concerned, the court shall strike out the proceedings. So, if a matter has gone into abeyance for 12 months or more, no action, nothing being done, the registrar of the court may bring it to the attention of the court for the court to have them strike out. And sometimes they're necessary because if we take courts, especially the trial courts, they're what we call the monthly returns, right? Judges are also subjected to all manner of scrutiny to ensure that they're working hard. So the monthly returns they're supposed to submit. And we have what we call the monitoring evaluation unit, under the auspices of the Chief Justice. And they will be finding out how many cases are standing on your list. If you have too many cases, the question is, why are they there? What progress have you made? It may well be that it's not your fault as a judge because the parties have not come in. And that is why a judge or the court will have to prompt the registrar, conduct an audit, all cases which for more than 12 months, nothing has actually happened. Please bring a list and then the application. And then let's say notice on the parties. I'm going to take a decision. So once the parties are notified, now the court is going to hear application to have these matters strike out. If you don't show up and it's proving that you were served, the court will go ahead and strike it out for want of prosecution. And that is why in the Donko against Kusi, for example, it was held that before striking out an action, there must be no proceeding for 1 year, which is the same as the 12 months. And the party must have been given notice of intention to proceed. And failure to satisfy this condition invalidates the order striking out the action. What does that mean? If we look at Order 37, Rule 3, there is a rule to the effect that where 6 months have elapsed and no step has been taken in the case or the proceeding, you cannot just start, acting as if everything is normal, all right? The law requires that you serve a notice of intention to proceed. So there's what we call a notice of intention to proceed. That would be the process. You have the title of the case, the court, and then you file notice of intention to proceed pursuant to Order 37 Rule 3. Then take notice that the plaintiff or the defendant hereby intends to proceed with the case. And once you have filed that, Order 37 Rule 3 requires that you must wait for not less than 28 days. So you file a notice of intention to proceed. So the notice of intention to proceed after elapse or after expiry of 28 days. So after 28 days, the way is clear for you to continue with the case. Now, if the case has lie fellow and you haven't done anything and you're a party and you want to continue, you must file the 28 days of notice of intention to proceed. And assuming you want to actually have the case strike out for want of prosecution, supposing you are the defendant, you file the notice of intention to proceed. Now, after 28 days, the plaintiff has not done anything. You just bring your application asking the court to dismiss or strike out the action for want of prosecution. And that is what is required to be done if you want to have the matter strike out for want of prosecution. Good. Now let's talk about evidence at trial. All the things we have learned in the law of evidence are important. Suffice to remind ourselves that the Evidence Act 1975, NRC Decree 323, governs, among other things, admissibility of evidence. In other words, what evidence is permitted by law to be received as being a material on basis of which the court should make adjudication, a determination as to who is right, who is wrong, whose rights should be upheld, and so on. And then Evidence Act also governs burden of proof. Burden of proof, who has the legal obligation to convince the court as to whether he has a case against the other or as to whether something happened or did not happen. Now, if you look at CI 47, it governs the procedure for adducing evidence. It does not govern the rules on its admissibility of evidence or burden of proof and so on. You have to look at there's NRC Decree 323, the Evidence Act for that. If you look at Order 36 reform, you notice that it gives the sequence of trial proceedings, like the order of proceedings to follow when it comes to the trial, as it were. So basically, the plaintiff will open the case. When we say the plaintiff opened the case, we don't have the practice in Ghana, although if you look at the rules, in principle, it shouldn't be impossible to give, if you like, open speech. It's not done. It's not done, but if we look at the rules, particularly the 36 reform, we say that unless the judge before whom an action is tried give direction as to the party to begin and the order of speeches at the trial, the party to begin and the order of speeches shall be that provided by this rule. Then Order 36 reform 2 says that subject to says the plaintiff shall begin by opening the plaintiff case. So the plaintiff opened this case, and when the plaintiff opens the case, what it simply means is that the plaintiff is going to man the boss, either by himself or by his witnesses, and then call evidence. As you know from John Mahama against Akufo-Addo, the 20 and the Electoral Commission 20 electoral presidential petition, it is not mandatory for a party to lead evidence. A party may elect not to lead evidence. Again, a party who intends to give evidence need not testify himself. There's no rule which says that if your party must testify yourself. You can have witnesses that will testify on your behalf, and that will still be good. Nobody can say that, why is it that you are the plaintiff and you have not entered the box? You just brought witnesses. There's no rule which said, in any case, whatever the witnesses are going to say are on his account, and he is running a risk. If he thinks that the witnesses can better speak to the case than himself, why not? So the plaintiff opened his case by presenting the evidence. The witness testify. Any documentary evidence is what is tendered. The, the, the defendant may elect not to call evidence. If the defendant elects not to adduce evidence, the plaintiff closes the case and the defendant addresses the court. Now, if the defendant calls evidence, then the defendant will have to open his defense after plaintiff has closed his case, and the defendants and witnesses will testify. And then in that respect, within the context of the 36 reform, the closing speeches, or what they call the address, will be as follows. So the defendant will address the court first, and then the plaintiff will reply. But in practice, these days, a lot of trial courts, at the end of the trial, may give simultaneous order that the parties are to file their addresses at the same time, meaning that the plaintiff will file and the defendant will file, and the plaintiff has not had the benefit of reading the defendant's address, as it were. So that one is not an inflexible rule. It depends upon the discretion of the trial judge, as the case may be. Now, where you have multiple defendants, that is, we have more than one defendant and they appear separately, that is to say that they are not conducting the defense together. Each is conducting his defense separately, and they may also have their separate lawyers, as the case may be. In that case, each defendant will proceed in the order they appear on the record. So if maybe you have 5 defendants, first defendant, second defendant, third, fourth, fifth, good. Now, when the plaintiff has finished his case, the first defendant will open his defense. And when he finishes, second defendant, third defendant, until the fifth defendant. So that is how it is done. Now, let's say a few words about examination of witnesses. So first, we have the examination in chief. Examination in chief. Examination in chief, as we have alluded to when we're looking at CI 87, which amends CI 47, we have noted that now examination in chief is simplified in the sense that the evidence in chief, which will be given an examination in chief, is reduced into what? Into writing in the form of witness statements. But we still have to remember that examination in chief is where the witness called by a party is first examined by that party. So if you are plaintiff, you are calling a party, or defendant, you are calling a party, you, the one called the party, will have to examine the witness. And in examining the witness, because it's your own witness, you are not allowed to behave as if you are cross-examining the witness, only assess the witness to tell the story. But this will be done already by the witness statement. So the purpose is to elicit facts which are favorable to the case of the party. So that is the examination in chief, and the witness must testify on oath or affirmation. You cannot testify without swearing oath or making some affirmation, because you want you to have the presence of mind that what you are doing is not a joke, that what you are doing is quite grave, severe, and you must appreciate the obligation to be truthful in that examination that you are doing. And of course, we know from your law of evidence that the witness must testify based on personal knowledge, and that is very important. The personal knowledge is important. And when you are writing, the witness statement, it is a good practice to let these ideas, reflect the fact that, yes, you're the witness, you're saying that, yes, I know about the matters related to the subject matter of this litigation. So you are testifying on basis of your personal knowledge. And as you know, as a general rule, hearsay evidence is inadmissible. Matters that you do not have personal knowledge about, but you learn of it from second party, third party, fourth party. It is, as a general rule, not admissible. So let us keep that in mind. And we should also remember that leading questions are prohibited in examination in chief. And when we say a leading question, is one which suggests the answer desired by counsel. You ask a question and then the desired answer is contained in the question. Oh, you have eaten already? Not so. Now, what you want to find out is that you want to find out whether the person has eaten. But how you presented the question, it suggests the answer. And that is not permitted in examination in chief as a general rule. And the reason for preventing leading question is to prevent coaching of witnesses, where you coach a witness so that the witness will just come and parrot that what he has been, coached to say. That is not good. Or it also exists to preserve spontaneity and authenticity of testimony. The testimony should be spontaneous and it should be more authentic. And also ensure that the evidence is truly that of the witness. And that is why leading questions are prohibited in examination in chief. But we have exceptions. Leading questions may be allowed on introductory matters. Matters, for example, your name, your name, where you live, and so on. Or on undisputed facts. There are some facts which are not disputed. Those ones, you can lead the witness and it will not attract objection. Or where a witness is declared hostile, you call a witness and then you would like to get the leave, permission of the court, to treat the witness as a hostile witness, as a witness who you have called, but he has made up his mind to just undermine your case from ill motive. Then you'll be allowed to confront that witness as if it was somebody's witness that you are cross-examining, in which case leading questions are permitted. Now, as we have noted, hearsay evidence, which is a statement made outside the court, intended to prove the truth of its contents, is not generally permitted. So if you look at the Evidence Act, we have a whole lot of rules on that. You've learned law of evidence, so it's not for me to teach you that which you ought to have learned already. So section 63 to 75 reminded of the Evidence Act will remind us that hearsay is generally excluded unless it falls within the recognized or the exceptions. So, for example, when it comes to examination in chief, a witness must not repeat what others told him. So in the witness statement, don't repeat what somebody told you, unless it falls within the recognized exceptions, such as maybe admissions or dying declarations or business records, which you know. Now, when you are doing the examination in chief, let me say this, that despite the fact that we have a CI 87, it is still permissible if the court is of the view that a witness who has been called should be allowed to give oral examination, evidence in chief. So yes, CI 87 is there to ensure that we expedite, trial by requiring witness statements to be filed and served. However, as I indicated, it is possible for the court to give oral evidence, even if it's not covered in the witness statement. So let's look at the order. Let's look at the Rule 3E, okay? Order 38, Rule 3E of CI 87, who says that if a party has served a witness statement and that part wishes to rely at the trial on the evidence of the witness who made the statement, the party shall call the witness to give oral evidence unless the court orders otherwise, or that party puts the statement in as a hearsay evidence. And two, where a witness is called to give oral evidence under Sub-Rule 1, the witness statement of that witness shall stand as evidence in chief of that witness unless the court otherwise orders. A witness giving oral evidence at trial may, with the permission of the court, give evidence in relation to any matter which has arisen since the witness statement was served on the other parties. And then 4, the court will grant leave under Sub-Rule 3 only if it considered that there is a good reason not to confine evidence of the witness statement of that witness. Now, the orders for filing witness statement might have been given, a couple of months and so on, and certain developments occur which are relevant to the case. However, they could not have been made part of the witness statement because they had not occurred at the time. So where a witness enters a witness box, assuming it's necessary for the witness to speak to those matters, the request will have to be made to the court for the court to decide. Or what also happens is that some people may bring application for leave to file what they call the supplementary witness statement in order to speak to those matters which have come up after the original witness statement was filed. So let us keep that in mind. Unless there's a question on the examination in chief. Otherwise, move on to cross-examination briefly. If you want to ask a question, just put up your hand so that I will raise your mic. For some of you, just allow the background noise to come into the. Okay. Right, there's no hand up. We have a cross-examination, and each party or each witness who has given evidence in chief through the examination in chief. As I said, if the person enters the witness box, I should maybe tell you also learned in advocacy. When the person enters the witness box, the person is made to take a note, and then if the person takes a note, if it's let's say with the Bible, we say that the SOB, let's say in English, shown on the Bible in English. If the person is a Catholic and use the cross, you say the SOC, sworn on the cross or sworn by the cross, let's say in English or tree or Ewe, as the case may be, or SOK, if it's a Muslim, sworn on the Quran, or we can just say affirmation if the person does not want to swear by any of these. So that is done, and then the person is made to identify the witness statement that yes, he actually authored that and signed it or approved it. So it's adopted as a person evidence in chief, and then the person is now handed over to the opponent to subject him to cross-examination. So cross-examination is the questioning of the witness by the adverse party after examination in chief, and because our system is adversarial, Cross-examination is very important stage of witness interrogation in the sense that it is the principal mechanism by which, first, the credibility of the witness is tested. Is the witness speaking the truth? The witness, has he got the capacity to speak the truth? Two, accuracy of the witness or of the testimony is scrutinized. What the person is saying, is it coherent? Is it accurate? And three, the truth is probed through adversarial challenge. If we want to know the truth, allow a person to be confronted by his adversary or his opponent, then the truth will come out. So, examination in chief presents a narrative, a narration, and then cross-examination interrogates and verifies the narrative. So the examination in chief free for you are just parroting your story good. But cross-examination will come and question or interrogate or verify the narrative. So the purpose of cross-examination is to test the truth of the testimony, and the cross-examination will prove whether the witness is truthful, whether the account is accurate, whether the testimony stands withstand scrutiny or it will collapse. And for that matter, cross-examination also has the aim of exposing inconsistencies. So the lawyer doing the cross-examination may confront the witness with the witness's prior statement. The witness has made certain statements earlier, and if those statements, for example, are inconsistent with his current testimony, the lawyer may confront the witness with the prior statements, or he may highlight contradictions within the testimony. They say that, Madam, you said this, and now you have also said that. So which of the two do you want the court to believe? Are you still standing by the two? So here, you have spotted contradiction. You are confronting the witness with that. And that will also help you to undermine the credibility of the witness or the witness testimony. And it also helps you to demonstrate unreliability of the witness and the witness testimony. And cross-examination, again, will help you to challenge the credibility. And the credibility may be attacked by exposing bias. You expose the bias, try to say, okay, because the witness, for example, has benefited from a certain gift from this party. That is why he's in the court to testify in the ways that he's doing. Or because the witness was previously married to somebody from a particular tribe, and the marriage ended quite, horribly, and then the other party in this case is from that tribe. That is why the witness is speaking the way that he's doing. So yeah, we cannot exhaust the manner and the techniques for trying to undermine credibility of the witness. So bias, or you may expose interest in the outcome, that the witness has got an interest in the outcome of the case, or previous inconsistent statement, as I indicated, or you may want to expose defects on the part of the witness with respect to perception, memory, or narration. Try to say that maybe you try to demonstrate that the witness, for example, has a bad or poor memory, and because of that, it certainly affects the accuracy of the testimony that he's giving. So all those things are some of the things that may happen. So all the things we learn in the evidence law with respect to impeachment of credibility are very much applicable here. Again, cross-examination may be used to elicit favorable facts. Facts will support your version of the case. You can use cross-examination to bring it. And in fact, when judges are deciding cases, they pay more attention to evidence from cross-examination than the evidence in chief, because cross-examination evidence are properly being tested. So cross-examination may help you to extract admissions from your opponent, establish facts supportive of the cross-examiner's case, as the case may be, and the pressure of authorities, including the Foley against the IRB, and then where the Supreme Court will remind us that where a witness is not cross-examined on a material point, the opposing party is deemed to have accepted that evidence. And this point is very important. What do you mean by that? Your opponent has given a certain testimony, and the testimony is not just anything, very pertinent matters relating to the controversy before the court. And you don't cross-examine the witness on those material points. Then what it means is that by implication, you have no problem with what the person has said, and you want the court to take it as it is, and that will be taken. So failure to cross-examine on the material point means that you have accepted or you are deemed to have accepted that particular evidence. So cross-examination is not optional where facts are disputed. So if there are certain facts, right, which your opponent has disputed it by the pleadings and so on, and you have the opportunity to cross-examine and you don't cross-examine on those matters, then what it means is that you have accepted the version of your opponent and the court to endorse that. So failure to challenge the evidence amounts to implied or tacit admission. And that is why when you are conducting a trial, you have to be very attentive. Know the essential matters in controversy. Make sure that your cross-examination does not fail to address those particular things. Again, in cross-examination, the counsel doing the cross-examination must put your case to the witness. So cross-examination is also putting your version of the case to the witness, but the witness will also endorse it. So you are testing your own case through the mouth of your opponent. And of course, you notice that cross-examination is very much linked to fair hearing, as a witness is given opportunity to respond to allegations. Allegations are made, yes, the witness will be given opportunity to respond to them. And a party cannot ambush each other at the address stage. So now we have a clear idea of matters which can be the subject matter of cross-examination. All the things we learn in evidence, I said, are important, except that, yes, it is often said that in cross-examination, the sky is the limit, meaning that it is more or less at large. That is true, but where the court is so minded, the court can prevent you and say that you haven't demonstrated the relevance of what you're doing to the matters before the court, as the case may be, and you will have to do that. It's not enough for you to say that, my Lord, allow me, I do my case, I know what I'm doing. Well, maybe one or twice you can be indulged by the court, but if you are really going really off, the court will like you to show relevance. Or if you are just harassing the witness, the court will prevent you from harassing the witness, or if you are trying to press the witness. Sometimes some lawyers may want to embarrass certain witnesses for just embarrassing sake. That may not be permitted, despite the fact that the person is being examined. And again, when it comes to cross-examination, the scope, as we said, the credibility matters. That is one. And two, collateral matters. Collateral matters are matters which may affect credibility indirectly. So those ones are permitted. They don't have to overdo it. And again, leading questions. Leading questions are permitted in cross-examination because cross-examination, the person making the leading question is the opponent. And if the cross-examining, for example, we see that, and then the car was actually moving at 80 kilometers per hour at the time that the tire burst. That is correct. Not so. So here is a leading question, but because it's cross-examination, it's permitted. And in fact, a good cross-examination should, as much as possible, incorporate a lot of leading questions because it enables you, the cross-examining party or counsel, to control the narrative. You box in the witness and you're giving the witness a limited option. And that option is contained in the answer is contained in the question that you're giving. Instead of giving what you call open-ended question, you allow the witness to go to town and write thesis, as it were. No. Cross-examination, you have to control the narrative and then test the witness rigorously. Of course, cross-examination is under the control of the judge. That is very important. So the trial judge must ensure that the cross-examination remains relevant or is conducted fairly. It does not degenerate into abuse. So the court has a responsibility. And in fact, as if you look at the section 69, I don't have my evidence act with me at where I am. But if someone has the evidence act, and somebody's reading section 69 for us. Section 69, can you read it for us? Evidence, I think read section 69. I don't have my act with me, but read it for us. Who's reading? If you have your evidence, I'll read section 69 for us. I want to find out something. Okay, Marvin, let's hear you. Marvin, let's hear you. You can unmute the mic. Unmute the mic. Yes, go ahead.
Okay. Section 69, mode and order of interrogations. The court shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to A, make the interrogation and presentation as rapid, as distinct, and as readily understandable as may be, and B, protect witnesses from being unduly intimidated, harassed, or embarrassed.
Good. So, Section 69 of the Evidence Act is very important as it reinforces the power of the court to exercise control over cross-examination. So, cross-examination should be robust. Nevertheless, it must remain within the bounds of judicial propriety. It must be proper. And the court under Section 69 is supposed to ensure that evidence is as rapid, evidence does not actually intimidate or oppress or embarrass the witness, as it were. It's particularly so where it's not relevant to the issues involved in controversy. So let me give you a very funny example. Let's say that a witness is in the bus and you ask the witness, so last year you didn't pay your taxes. And let's suppose that the case has got nothing to do with, and you're not able to show any relevance. I mean, that is not fair. Or you as a witness, so last night you didn't make love to your partner. Is that correct? It's good unless it's maybe like it's really relevant to a matter in issue. Otherwise, these are matters which are supposed to embarrass the witness, and that will not be allowed. So cross-examination is the right of the parties. You must actually confront your opponent, isn't it? It's also a tool of truth finding. And let's say a few things about re-examination. So after cross-examination, there may be what we call re-examination. And I said maybe, I didn't say there shall be, meaning that re-examination is not automatic. It is conducted by the party who called the witness. So a party whose witness has been just cross-examined, he will do the re-examination. And as I've indicated, it's not automatic. It is strictly limited in scope. And the purpose of re-examination is to clarify matters arising from cross-examination. Maybe there may be ambiguities, and it's necessary to remove the ambiguities, or there may be some inconsistency which may need to be explained so that the evidence can be understood, or it may be necessary to repair damage caused during cross-examination. But it's very restricted. And the emphasis here is only matters arising from the cross-examination. If what you are seeking to re-examine cannot be demonstrated to have arisen out of the cross-examination, you will not be permitted to do the re-examination. So it's not opportunity for new matters. New matters are prohibited. You cannot do re-examination to introduce new evidence, to reopen examination in chief indirectly. No, you can't do that. If you need to reopen examination in chief, you need to come specifically before the court for leave, for the court to decide whether it is fair and proper. And that is why in the case of Jiasu, DZIASU, Jiasu against Ghana Brewers Limited, 2007-2008 Supreme Court of Ghana report 539, the Supreme Court will remind us that re-examination is not an opportunity to rebuild a weak case. It is strictly confined to clarification of issues raised in cross-examination. And that is very important. So,
And so when you go online and you apply, you put
so just before we leave these aspects of the trial, I want to focus a bit more on the leading caution with star witness, since sometimes, although it is not evidence class, a civil procedure, it can be an examination area. So leading question, as we have noted before, is one who suggests the answer, which the questioner desires or expects. And typically, it is framed in such a way that the witness is invited to confirm rather than narrate. So the witness is supposed to confirm rather than narrate or explain, as it were. So you have a question like this. You were at the scene at 10 p.m., weren't you? So here, the witness is only supposed to confirm whether he was at the scene at 10 p.m. And nobody asking him to explain where he was or what he was doing. No. And certainly, leading questions are tightly regulated as they risk distorting the authenticity of the testimony. And that is why we saw that the general rule is that in examination in chief, they are not permitted. They are not permitted. And the exception, as we saw, is that certain introductory or matters of formality, such as name, address, occupation, background facts, which are not contentious or do not affect substance of the dispute, can be subject matter of a leading a question, which is permitted even in examination in chief. There's no problem. And again, undisputed facts, where a fact is a common ground between the parties, not in dispute or not in issue, leading question may be used to save time and to streamline proceedings. Matters which are not disputed, if your opponent present a leading question for the other, his own witness to confirm, you shouldn't find objectionable. In any case, we haven't controverted it, and it will let proceedings go very fast, as it were. But as we've noted, in cross-examination, that is where is a proper place for leading question. The reason being that cross-examination has adversarial function, and it seeks to test the truth of testimony, to challenge credibility, expose consistency, and that is why leading questions will allow the cross-examined party to control the narrative, confront the witness directly, and exact admissions efficiently without wasting time. Again, there is a strategic function for leading question. Because through leading question, the lawyer conducting the cross-examination may pin down a witness to specific answers or highlight contradictions in the witness's testimony and limit evasiveness. Some witnesses are evasive. So if you are dealing with an evasive witness, as a good cross-examined lawyer, you must make good use of leading questions. That way, the witness cannot be evasive, meaning that he cannot try and be all over the place trying to avoid answering the question, because leading question will box or you pin that witness down. But despite the permissibility of a leading question in cross-examination, the court still retains the supervisory authority, as we saw under Section 69 of the Evidence Act, where, among other things, for example, the court is of the view that leading questions are oppressive, misleading, irrelevant, repetitive, or abusive. The court may disallow it in order to ensure that there's fairness, dignity, and integrity of proceedings. Now, let's say a few things about hostile and adverse witnesses. As I said, you've done this in your law of evidence already, but because we are discussing trial, we need to revisit them and put them in perspective. So, in law of evidence, we have a distinction between hostile witnesses on one hand, and then adverse witnesses on the other. And in some cases, there's a third category which is not quite pronounced, what they call the disappointing witnesses. A disappointing witness may neither be a hostile witness or adverse witness, but we'll look at that in a minute. So the classification of a witness as being a hostile or what do you call the unfavorable witness? I mean, hostile or adverse witness is very important because it will help us to know the manner of questioning permitted and whether the party calling that a witness may cross-examine his own witness. It will depend upon whether he's a hostile witness or adverse witness. So the law recognizes that a witness called by a party may not always support that party's case. That is fine. After all, the witness is supposed to tell the truth. And if what the witness, for example, considers to be the truth is not supporting the party calling that party's case, why should we prevent the person? And that, feasibility is proper. So then, who is a witness, a hostile witness? If we look at the evidence law and common law generally, a hostile witness is a witness who demonstrates hostility towards the party calling him or shows an unwillingness to tell the truth. So somebody has called you as a witness, but then you come to the witness box and then you demonstrate hostility towards that party who called you, or you demonstrate that you know the truth, but you don't want to tell the truth, probably because the truth would be favorable to the party calling you, and you don't want the party to benefit from that. So hostility may be inferred where the witness, for example, contradict prior statements, exhibit bias against the calling party, deliberately withholds the truth, or gives evidence inconsistent with expectations in a manner suggesting antagonism. I mean, certainly, before you bring a witness, you have done what you call the pre-trial meeting to try and understand what the witness knows about the case, so that as you go to the court, you have a reasonable idea of what to expect from the witness to be saying in the witness box. And then let's say that you go and you notice that almost everything this witness is saying is inconsistent with the expectations in a manner suggesting antagonism. Then that may be evidence of a hostility. So what are the legal consequences? Where a witness is declared hostile, the court may permit the party who called the witness to cross-examine him. So despite the fact that he's your witness, but if you can demonstrate that this witness has brought himself up to the threshold of hostility, then the court may permit the party calling the witness to cross-examine that witness. And this is a significant departure from the general rule that a party may not cross-examine his own witness. So this witness is not another witness. This is a hostile witness. And once declared a hostile witness, leading questions becomes permissible. The party may impeach the witness' credibility, and prior inconsistent statement may be put to the witness. So this will transform the witness into one akin to an opposing witness. So let's suppose that you have a witness statement. You have a witness, right, who has offered the witness statement. So the witness enters the box and he identified the witness statements and so on. And then he's told that, what do you want to do with this? Then the witness, for example, said that, I want to rely on this witness statement, and also I have a very important thing to add. And then the person will start talking plenty. And because the person is under oath, and if you're under oath and you're speaking, it's on record. And you notice that, for example, what he has said is at variance with what the witness is even saying, then certainly you will notice that this witness is a hostile witness. So the court may permit leading questions to be, because he will be subjected to cross-examination by the party who actually called him, as it were. Then we also have adverse witness, or what we call unfavorable witness. An adverse witness is one who gives evidence unfavorable to the party calling him. Now, this witness, this adverse or unfavorable witness, is not exhibiting hostility, except that his evidence is not just favoring the party who called him, but he's not doing that out of hostility. So in the case of an adverse witness, not a hostile witness, the law is that the calling party cannot cross-examine him. You cannot cross-examine your witness whose testimony has become unfavorable to you because no hostility has been demonstrated. Leading questions are not automatically permitted. So the party calling the adverse witness or the unfavorable witness is bound by the testimony of the witness. So let us know the distinction properly. The distinction between a hostile witness and adverse witness, also known as unfavorable witness, is that in the case of a hostile witness, it shows hostility, including untruthfulness. And for that matter, the party calling the hostile witness with the leave or permission of the court may cross-examine the hostile witness. Again, we have the adverse witness or the unfavorable witness. Now, this adverse witness is merely unfavorable, meaning that his testimony is simply not helping the case of the one calling, but he's not doing that out of any malice or any hostility. And for that matter, there's no right to cross-examine such a witness. What about, we also have a situation where a witness may not be hostile or adverse. Mr. Kwame Tete in his work would call such the third category they call like a disappointing witness. We have, let's say, a witness who is disappointing not because he has any hostility or not necessarily because his evidence is not favorable and favoring you. Let's suppose that either the witness is generally not intelligent or maybe poor memory or something like that. And with that matters which you think that the witness should have been able to give a good account of. The witness is not forthcoming due to some of those things. So that is a disappointing witness. It's not a hostile witness. It's not an adverse witness. So let's keep that in mind. So how do we actually to get the court to accept that a witness should be declared as a hostile witness? Well, first and foremost, the declaration of hostility is not automatic. It is subject to judicial discretion. What are the steps? One, the lawyer for the party calling the witness will apply to the court. And then the lawyer will have to give the grounds of hostility. What grounds of hostility are demonstrated? And then the court will have to evaluate the witness conduct. And then the court will make up its mind whether leave should be granted or leave should not be granted. So the court will consider whether the witness is deliberately evasive, whether there's inconsistency with the prior statements, whether the witness demonstrates bias or antagonism So the court will look at all this before making a determination as whether the witness can properly be treated as a whistleblower witness. So look at the case of Ray Okine disease, Dodu against Okine. Ray Okine into bracket deceased, Dodu against Okine, 2003-2004, SCJLR, Supreme Court Ghana Report 582. And the Supreme Court discussed the principles governing hostile witnesses and made the point that hostility must be clearly established, that mere unfavorable testimony is insufficient, and that the discretion to declare witness hostile must be exercised judicially and cautiously. So let's keep that in mind. Good. Let's say a few things about documentary evidence before we move on. Now, before we talk about documentary evidence, remember that we have already talked about what we call the labeling of exhibits. You know how exhibits are actually marked or labeled. So if you look at the 36 rule 8, the 36 rule 8, that the clerk of the court shall take charge of every document or object put in as an exhibit during the trial, and shall make or label each exhibit with the letter or letters indicating the party by whom the exhibit is put in or the witness by whom it is proved, and with a number so that the exhibits put in by a party or proved by a witness are numbered in one consecutive series. So the clerk of the court shall cause a list to be made of all the exhibits in the action, and any party may, on payment of the prescribed fee, have an office copy of that list and any documentary exhibit. Then the 36 rule 8 sub rule 3. The list of exhibits, when completed, and any documentary exhibit shall be attached to the pleadings. It shall form part of the record of the action. So for the purpose of this rule, a bundle of documents may be treated and counted as one exhibit. So in practice, what happens is that we use alphabet to designate exhibits put before the court by the plaintiff. So exhibit A, exhibit B, exhibit C, D, in that order. And then we use numbers or numerals. So exhibit 1, exhibit 2, exhibit 3, exhibit 4, to designate exhibits put before the court by the defendant, as the case may be. So when we say documentary evidence, we are referring to documents tendered in court to prove the truth of their contents or the existence of facts recorded therein. So in litigation, documentary evidence is very important because it provides objective and permanent records. As we often say in our language, literally translated, book no lie, isn't it? Book no lie means that the thing is there. I feel it. It says what it says. And documentary evidence carries greater probative value than oral testimony. And for that matter, when it comes to commercial and various civil disputes, it is like the backbone of the evidence if it's available. And all the things in law of evidence regarding requirement for admissibility are applicable also to documentary evidence. So for documentary evidence to be admitted, 3 cumulative conditions must be satisfied. 1, relevance. 2, admissibility. And 3, proper proof. So let's explain this. First, relevant, the document must relate to a fact in issue. You don't just exhibit any document for putting anything before the court. Is it relating to any of the facts in issue, any of the contested matters? Or it must relate to a relevant fact. It must relate to a relevant fact. So you look at the your Evidence Act, look at the sections 1 to 5. And irrelevant documents are inadmissible regardless of authenticity. So it's not just a question of it being authentic. If it's authentic, that is good, but does it relate to any fact in issue? Again, admissibility, the document must comply with what? Rules relating to hearsay, privilege, stamp duty. So all the principles relating to hearsay will have to be satisfied as applies to documents, and privilege in terms of maybe certain documents not to be disclosed and so on, confidentiality, or stamp duty. If stamp duty, the case of Zoris, stamp duty must be paid, and it's not paid, it's not exigible on it, it's not admissible. So a document may be relevant but still inadmissible in law. So look at it. So first, we saw that a document may be authentic but not admissible because it doesn't relate to what? Because of it doesn't meet the threshold of relevance. Relevancy is not met, okay? And then we're also saying that a document may meet the test of, may be relevant, but inadmissible because certain rules stated in the law, like hearsay, privilege, or payment of, or the stamp duty law says that once the requisite the stamp duty has not been paid, it's not admissible. Then the third requirement, proper proof, the document must be authenticated, identified by a competent witness, and a link to the facts in issue. So all this must be satisfied. So proof may be by maker of the document, the person who made the document, and that is why we say that there should production from a proper custody or a person with the knowledge of its contents. Or maybe we have a statutory exception. If you look at the Evidence Act when it comes to business records, for example. Now we also have the best evidence rule. The best evidence rule simply means that the original document must be produced as the best evidence of its contents. And this ensures that we have accuracy, reliability, and prevention of fraud. So if you have a document, we prefer the original document as a general rule. And that is the best evidence of what the document says. And as I've said, the benefit of having the original is to guard against inaccuracy, unreliability, or fraud. Of course, we have an exception where secondary evidence, rather than the primary or the original document, may be admitted. So exception to the best evidence rule, that is where you cannot have like the original tendered. For example, the original is lost or destroyed. The original is in possession of the adverse party. Production is otherwise impracticable. So where it is not, we have these situations, then secondary evidence like copies, right? Like copies or photocopies of the original may be admitted, and that may be exception to the best evidence rule. So here, there's an attempt to strike a balance between evidential integrity and also practical necessity. Evidential integrity in the sense that, yes, we want the most authentic, and the most authentic will be definitely the original. But then we are also aware that it is possible that by all diligence and genuine effort, the original may not be obtainable. But then if we have no indication that a copy of the original is available, why should we deprive ourselves the benefit of it? On stamped documents, that is another important statutory limitation admissibility. So if you look at the Stamp Duty Act 2005 at 689 as amended, an unstamped document is inadmissible in evidence. This is a mandatory requirement, it's not discretionary. A trial court does not have the choice. It's not trying to show favor or be nice to anybody. It is either stamped or it's not stamped, and then it's not admissible. If it's not stamped, it's not admissible. As simple as that. So if you look at the case of Nati against Mechanical Lloyd Assembly Plant Limited, Nati against Mechanical Lloyd Assembly Plant Limited, decision of 1987-88, 2 Ghana Law Report 314, the Supreme Court emphasized that an unstamped deed is legally worthless and cannot be admitted for what it is worth. Now, in the past, there used to be this practice where the trial court will say that, okay, the document is not stamped, but let it go in for whatever it is worth. No. It is either stamped and it's admissible, or it's not stamped and it's inadmissible. So, Nati against the Mechanical Lloyd, and of course, we come and talk about the Lizori's case, makes the point quite categorical that inadmissibility is absolute. It's on stamp, it's inadmissible. The court has no discretion to admit such a document. And the defect goes to legal validity, not merely weight. Because if it is a threshold thing, you are stamped so that you can enter the room of evidence. You are not stamped, you don't enter. So it's not a question of, oh, let it be there, and then we'll not attach much importance to it. No, it doesn't work that way. And if you look at the Courts Act, section 109 of the Courts Act 1993 at 459, there is a provision to the effect that where an objection is taken in court to the inadmissibility of a document in evidence on the ground of absence or insufficiency of a stamp, the decision of the court shall not be reversed, set aside, or otherwise interfere with by reason only of a ruling of the court that the document requires a stamp, or that the stamp on the document is insufficient, or because the document does not require a stamp. So the effect of section 109 of the Courts Act is that an appellate court will not interfere solely on the basis of a wrong ruling on stamping, no. However, this does not invalidate the position of the law that an unstamped document cannot be admitted. All that section 109 of the Act 459 is telling us is that it limits appellate intervention on that specific ground. So if, let's say that the only ground of the appeal is that there was a wrong ruling on the requirement of stamping, then that is not enough for reversal or interference with the decision of the trial court. But as I said, that does not actually water down the other position of the law that an unstamped duty is not admissible. The relatively recent case of Lizori Limited against Boy and School of Domestic Science and Catering, 2013-2014, Volume 2 of Supreme Court of Ghana Report, page 889. The Supreme Court, speaking through Benin GSC, among other things, will tell us that, quote, where a party had blatantly refused to comply with a legitimate directive, order or instruction of a court to pay stamp duty, that court will be justified to reject a party's request to admit those documents in evidence. Either the document has been stamped and appropriate duty paid, or it should not be admitted in evidence. There was no discretion to admit it, unquote. So, Lizori limited case has actually clarified the position that no discretion exists to admit unstamped documents. Compliance with the stamp duty is a condition precedent to admissibility. It is stamped and is admissible, or is unstamped, is not admissible. Any question? Okay, so let's say a few things about inspection of locus inco as part of our trial of the discussion of the trial. I don't see any hand up, so I continue. So there's what we call the locus inco inspection, locus. So locus inco literally means the place in which the subject matter of the dispute is situated. So inspecting the locus inco will be the physical visit by the court to a place where to a place relevant to the dispute for purpose of better understanding of the evidence. Maybe if it's about maybe land litigation, for whatever reason, if it is necessary for the court to understand what is at stake. So there's a need for physical visit that to be done. And we call that the locus inco inspection of the locus inco. And it is not an independent evidential process. That is to say that the locus inco is not meant for the judge to go and gather evidence. No, it is just an aid to the proper evaluation of the evidence already before the court, to help the court to understand the evidence properly admitted already. So the principal objective of the locus inco inspection is to assist the court in appreciating and understanding evidence. So maybe to enable the court to clarify conflicting testimonies, understand physical features of the subject matter, assess credibility of witnesses in light of the physical setting of what is being controverted, and resolve issues relating to identity, boundaries, or location, as the case may be. And the locus inco is part of the court's inherent jurisdiction. Inherent jurisdiction in the sense that the court has the power to adjudicate the matter. So if in adjudicating the matter, it is necessary for the court to, let's say, that go to the particular site so as to understand what is being talked about, why not the court to do that? And of course, it should be exercised in the interest of the justice and factual clarity. So that is very important. Yes.
Hello.
So in the case of Salisbury against the Woodland, 1969 300 report 863, the court will remind us that, quote, a judge may visit the locus inco to appreciate the evidence, provided that no prejudice results. And that is why we said that the locus should certainly be for justice and factual clarity. It shouldn't be to the disadvantage of any of the parties, as it were. Again, in doing the locus inspection, certain procedural safeguards must be observed. First, presence of the parties. The parties and their lawyers should be present during the inspection. And this will prevent ex parte impressions or unilateral advantage. So the court cannot go to the physical location with just one party. It must go with both parties and their lawyers. There should also be transparency. Inspection of the locus should form part of the proceedings. So there should be proper a report which is made. And later on, when the court comes back, it will have to be, if it's going to form part of the record, it will have to properly be tendered so that it's made part of the record. And a judge must not rely on personal observation as independent evidence. In other words, it's not enough for the judge to have gone to the physical location and said that, oh, I saw this, I saw that, and then you let that be part of your judgment. When there is no independent evidence of that visit and what transpired during the visit, being captured in record and being tendered and made part of the record before the court. Now, not until that is done, a judge cannot rely on personal observation during the physical, inspection. Observation must be used only to understand and evaluate the existing with evidence, as it were. So we have to remember that inspection of the locus does not replace oral or documentary evidence. It does not introduce new facts into the record. Rather, it contextualizes evidence and enhances judicial understanding or comprehension of the evidence. So let's keep that in mind. So when it comes to certain types of litigation, locus inspection may be significant, such as land litigation. Land litigation maybe sometimes, particularly in the countryside, in the past, where for now with the Land Act of 2020, the Act 1036, which requires that there should be a composite plan in almost all land cases. Locus inspection may not become very important as it used to be in those days, particularly with boundary disputes or identity of the land or possession, occupation, as the case may be. Now, when it comes to tort cases, particularly running down action, accident scenes, where the accident occurred, it may be necessary for the court to actually visit and see it, or nuisance claims. If there's a claim based on a nuisance, sometimes it may be necessary for the court to visit the locus. In commercial and construction disputes, sometimes the physical structures or the site conditions may be need to be inspected, for which reason there will be locus inspection. But there's a need for judicial caution. The court must avoid substituting observation for evidence, forming conclusion based solely on impressions, and relying on facts not tested by cross-examination. So those are very important. If this caution is not observed, when it goes on appeal, it can warrant interference by the appellate court, as it were. Now, just before we go, What is the role of the judge during the entire trial process? The role of the judge is one of judicial neutrality. The judge is the impartial arbiter of the proceedings. So his primary duty is to hear, evaluate, and determine the issues raised by the parties. The judge must not assume the role of investigator. It's not the judge's duty to be an investigator, to be an advocate or a partisan participant, no. And that is why, in the case of James against National Court Board, our venerable Lord Denning will say that a judge's role is to hear and determine the issues raised by the parties, not to conduct an independent investigation. Therefore, litigation is a party-driven. The judge must decide based on evidence presented, not evidence sought independently. Evidence presented, not evidence sought independently by the judge. And judicial neutrality is essential for fair hearing, goes without saying. Of course, a judge is supposed to pursue neutrality. That notwithstanding, the judge is not supposed to just be passive, because the judge may have to ask questions to clarify evidence. The evidence is for consumption of the court, and the court is the judge. The court is the judge. The judge is the one supposed to decide the case. So if the evidence is being led and you, the judge, you don't understand, and you keep quiet, you don't ask for clarification, it will help you to understand the evidence. How are you going to write your judgment? How are you going to write your ruling? How are you going to decide the case? So you are supposed to be neutral, but that notwithstanding, if you need to ask questions to clarify evidence, not to give advantage to anybody, but to help you to understand evidence, that may be done to resolve ambiguities or to ensure orderly conduct of proceeding, as we saw under Section 169 of the Evidence Act. That may be done. So the judge maintains control over the trial process. But it is important for the judge to avoid the arena of the conflict. The judge must not descend into the arena of the conflict. He must not, for example, cross-examine witnesses aggressively. If the court, so there are two schools of thought. One school of thought even says that a judge should not cross-examine a witness. But as I said, if the purpose is not just to cross-examine for cross-examination, but just to seek clarification and maybe remove ambiguity so as to understand the evidence, I mean, that is permissible. So the judge must not adopt the role of a counsel, must not display bias or prejudgment. And that is why a judge will have to be very careful in his or her utterances during proceeding, and especially during the trial. So the proper role of a judge requires a balance between active case management and strict impartiality. So the judge is supposed to ensure that proceedings are conducted fairly in accordance with law, and at the same time may intervene to clarify evidence, and such intervention must not compromise neutrality. So let's keep that in mind. Now there is also this phenomenon of reopening evidence. So let's say a few things about that before we end the trial, and we will have a minute or two break, and then we come back to continue. So reopening evidence, what is it? The court has the power to recall witnesses or reopen a case after it has been closed. So if you look at the Evidence Act, can anybody tell me a provision in the Evidence Act which permits a recall of a witness? Yes. Which provision of the Evidence Act permits or governs the recall of a witness? You're students of evidence law, so don't disappoint me. Yes. Which provision of the Evidence Act governs recall of a witness? Quote it for me. Ophelia, Ruth,
Section 79.
73, yes, quote it for me. Thank you. Read it for me.
Section 79.
Oh,
79.
yeah, 79.
After a witness has,
Read it, yes.
after a witness has been excused from giving further testimony in the action, the witness cannot be recalled without the leave of the court.
Okay, all right, thank you. Good. So, the court has the power to recall a witness, as is read for us from the Evidence Act, or even reopen a case after it has been closed. And reopening may occur to clarify existing evidence or admit newly discovered evidence. But this power should be used sparingly and cautiously by the court. And the Supreme Court in the Nuankra and Ankara, for example, has reminded us that the trial court has a discretion to recall a witness for further examination where justice so requires. So the governing principle is that whether the evidence is material, whether it could have been obtained earlier, whether reopening will cause prejudice, whether refusal will lead to miscarriage of justice. So therefore, if the evidence you want the witness you are recalling, or the case you want to be reopened, if whatever you want to do is said that it could have been done earlier, or the evidence could have been presented earlier when the witness was in the post, then the recall may not be successful. Or if it may lead to, it may prejudice the case of the other party. Maybe certain big wounds or holes have been created in your case, and you want to do damage control. So you want to recall a witness. That will cause prejudice to your opponent because your opponent has advantage, you having messed up your case. So you shouldn't be allowed to have a recall to repair your badly damaged case. So reopening must not be used to fill gaps in a party's case, to repair poor advocacy, or to gain unfair advantage. That will not be done. Okay, let's say a few things about race of subpoena, which is also important aspect of trial. Race of subpoena. A subpoena is a judicial process used to compel the attendance of a witness or the production of documents. So it's an order of the court, a process of the court used to compel, that is to force a person to appear as a witness or to force a person to appear and tender a document. It becomes necessary where a witness refuses or fails to attend voluntarily. Yes, the witness has a certain testimony or has a certain document, very much relevant to the matters in dispute, and it will even assess your side of the case. But here is the case: this witness is either not showing interest or is not really prepared to come. What do? The court has got a mechanism to help you to haul or drag the witness to come and speak to what he or she does. So we have two types, what we call the subpoena ad testificandum. Subpoena ad testificandum is issued to compel a witness to attend and testify. So the witness to just come and testify orally, like the witness was. And then we also have a subpoena duces tecum. subpoena duces tecum is issued to compel a witness to produce a document or material evidence. So this witness is not just his oral testimony, which is important, but because he has a certain particular evidence, especially usually in the form of like a document or something like that in his custody, and he needs to produce it for the benefit of the court as it tries to adjudicate the matter. So if you look at the Order 38, okay, Order 38 Rule 10, it makes reference to forms which may be used. So if you go to the ending part, that is the schedule, you have a form 14. So form 14 is the rate. I don't know if I can show my. It's 47. Stop machine. Can show it. Yeah. Okay. So if you look at this, you have the Form 14, which is referred to in the Order 38 Rule 10, 1. So the writ of subpoena ad testificandum or ducis. You have the title of the case, then the particular witness that you want to subpoena, right? The name will be stated, and then you are commanded to attend. The particular court is stated, right? Presided over by the judge sitting at. Then the location, the date on which the person is supposed to attend the trial is stated. Notice of which is hereby given to you, and from day to day, thereafter until the end of the trial, to give evidence on behalf of, and it's stated. Issued on. So here, it is a command. So it's added, if duces tecum, that is if the witness was supposed to come and produce a document or something, in particular, not just oral testimony, that means that you need a subpoena duces tecum, or some will say duce tecum, but in Latin it's pronounced the duces tecum. And it's added, and we also command you to bring with you and produce at the place aforesaid on the day notified to you. So we describe the document. So maybe like if it's a certain register or whatever, you describe the document, right, to be produced. Take notice that this writ is issued by the order of, then it's issued. I mean, this is a court order, okay? So that is the writ of the subpoena ad testificandum Form 14. And then we have a request for writ of subpoena. So this is so you put in the request to the address to the register, okay? So you use the Form 15 to put in the request. You're requesting the registrar to seal the rate of ad testificandum or the rate of the ad nodocis tecum, and then the registrar will now issue this form 14. So you are not going to issue it, but you put in the request in the form of form 15, and that will be done. So let us keep that in mind. And because it is a summons issued by the court, if you do not appear, that is contempt of court. You will be cited for contempt of court, and you can even go to prison, as the case may be. Now, if subpoena is taken, is issued, sometimes there may be a mistake. Okay, if you look at the 3811, it permits correction of a defects or errors in the subpoena. And you want to avoid the situation whereby somebody will come to court. The witness is summoned by a subpoena. Then you come and say that, no, my name is not spelled this way or that way. So if you look at the 3811, it says, and I quote, where there is a mistake in any person's name or address in a writ of a subpoena, which has not been served, the party by whom the writ was issued may have the writ resealed in the correct form by filing a second request under sub-rule 10.3, endorsed with the words amended and resealed. So it's possible to have any correction effected in the subpoena, as the case may be. And again, when a subpoena is issued, it also has what you call a duration of 12 weeks. If you look at the 38-12, a writ of subpoena shall be served personally, and the service shall not be valid unless effected within 12 weeks after the date of issue of the writ. So once it is issued, it has a lifespan of what? 12 weeks. If 12 weeks elapse, then you have to come under the 13. What do you call the 38-13, that the rate of subpoena shall after service continue to have effect until conclusion of the trial at which the attendance of witness is required. So if you have been subpoenaed, for example, to attend trial today, certainly the case may not finish today, or you may not be finished testifying today, but we don't need to serve you with another subpoena. The one you were served with will actually remain valid until there's no need for you as a witness, or until the case has concluded, the trial has concluded, as it were. Another point to note has to do with the record of proceedings. Record of proceedings. And record of proceedings is very important because during trial, we have an official record which is kept by the court, and the record will include the testimony given by the witnesses during the trial, the various rulings given by the court, and then the exhibit tendered. So that will form like the record of proceedings. Now, if you look at the Courts Act 1993 at 459, the record of proceeding form part of the official court record, and it has a very important function. It's a basis for judgment. The judge must rely on recorded evidence. The recorded evidence is that which is in the record of proceedings. Where there's an appeal, the appeal is based upon record. What we call the record of appeal, ROA, record of appeal. The record of appeal is based on the pleadings, the recorded evidence during the trial and exhibits, as well as any address which might be filed. These are the matters which will be transmitted to the appellate court for the appellate court to have a relook at it to find out whether the judgment which was given is consistent with the evidence on record, as it were. So the record is very important. And it also ensures judicial accountability, as it ensures transparency and preserve procedural integrity. So the record must be accurate, complete, properly maintained. And if there is any deficiency in it, it may affect validity of the proceedings and undermine appellate review. I would like us to pay attention to the Courts Act before I leave the record of the proceedings. So please, if you have your Courts Act, I don't have mine here immediately unless I go into the system. I want you to look at that. I think the section 69. Somebody should open section 69, section I think 70, 71 of the Courts Act, Act 459, with respect to the record of proceedings for us. Somebody should do that for us and then let me know. Not to have my Courts Act readily here. Yes, are you there?
Good evening, my lord.
Yes, good evening, Ruth.
Section 78.
Okay, 78.
Yeah.
What,
Every
what?
person
Yeah.
whose attendance is required
No,
under
69. Let's check
69.
69. 69, yes.
Section 69. In
Yes.
any proceedings before a court, the court may cause oral evidence to be recorded by shorthand,
Good.
tape recorder, or by such other means as the Chief Justice may determine.
Good.
2. The recording shall be done by an officer of the court or any other person appointed for that purpose. 3. A record taken under subsection 1 shall be transcribed by a person referred to in subsection 2, and the transcript shall, for all purposes, be the official record of the recordings in question. 4. Before any person other than the judge, chairman of the regional, circuit, or community tribunal, records or transcribes any evidence under this section, an oath shall be tendered to and taken by that person for the accurate and faithful recording of that evidence. 5. An officer of the court who has once duly taken the oath shall not again be required to take the oath in respect of the same or of any subsequent case. 6. The evidence shall be recorded under the supervision and control of the presiding judge or chairman, who may at any time before appending his signature to the written statement of the evidence amend anything in it which he considers requires to be amended. 7. Before signing, the presiding judge or chairman shall examine the statement and satisfy himself that it is in substance an accurate and faithful record of the oral evidence given. 8. If an officer or other person employed to record or transcribe evidence under this section willfully falsifies or misrepresent the true meaning of any oral evidence recorded under this section, A. He commits an offense and is liable on conviction to a fine not exceeding 100,000 cedis or to a term of imprisonment not exceeding 1 year or to both. Or B. He may be dealt with summarily by the court as for contempt of courts and be sentenced immediately to a fine not exceeding 50,000 cedis or a term of imprisonment not exceeding 6 months.
So which section are you now? Section?
I'm now going to 70.
Yeah, 70, okay.
Okay. Section 70. Subsection 1. No person is entitled to inspect or to have a copy of a record of evidence given in a case before a court or to a copy of the court's notes, except as may be expressly provided by the Constitution, a rule of court, or any other enactment. 2. If a person affected by a judgment or a court order desires to have a copy of the judgment, order, disposition, or other part of the record, He shall, on application for the copy, be furnished with it if he pays its cost, except where the court, for some special reason, thinks fit to furnish it free of charge. Section 71. In every civil or criminal proceedings dealt with in the High Court, Regional or Circuit Tribunal, the Circuit Court or Community Tribunal, minutes of the proceedings shall be drawn up and shall be signed by an officer of the court duly authorized by the judge or chairman of the tribunal. 2. The minutes with the notes of evidence taken at the hearing or trial, including any record of proceedings taken under Section 69 of this Act, shall be preserved as records of the court. 3. The minutes and notes of evidence, including the record referred to in subsection 2 of this section, or a copy of it, signed and certified as true copy by the officer referred to in subsection 1, shall at all times, without further proof, be admitted as evidence of the proceedings and of the statements made by the witnesses. Section 72, subsection 1. Any court with civil jurisdiction or its officers shall promote reconciliation.
No, it's okay. Thank you.
That's it.
Thank you. Yeah, so by combined effect of Section 69, 70, and 71 of the Courts Act 1993 at 459 as amended, the record of proceedings of the court, what has been recorded during the trial and approved as the record remains the official record. And you becoming lawyers, the advice I'll give you is that don't joke with the record of proceedings. So after, especially when the case is at the trial stage, it is prudent after every session, request for record of proceedings for that day, so that you go through. If there are mistakes, immediately bring it to the attention of the court at the next available date, so that the record is corrected. Otherwise, that becomes like the official record. And if there's a mistake in it which hurts your side of the case, that is it. Yeah, so don't let us treat that lightly. Now, finally, let's say briefly about address, and then we end discussion of trial. What do
My
you call
Lord, please, I want to ask a question.
Okay.
My Lord, respectfully, please, I want to know the difference between the minutes and the proceedings before the court. Because on the attachment that we are having, I see that the recorders will usually record all the proceedings, including cross-examination and then all of that. And then subsequently, the clerks or the lawyers would come later and request for the proceedings. But the minutes, can you please clarify that?
Okay, so minutes and the record of proceedings, they are all the same. The minutes is a subset, the record of proceedings, in the sense that what you're calling the minutes refers to, let's say, during the trial, what is being, the minutes of the trial, who said what was the answer. So these are all transcribed, and as she read for us at the end of session, I think there's 69 to 71, that the person doing the recording must even swear an oath. So before you become like a court recorder, you have taken an oath that you always make sure that you record accurately. And that is why, so the court recorders are working for the judge. And the judge will review it and approve that, yes, this is true. So I'll append my signature to. If there are mistakes, the judge will let them correct it. Yeah, so that is it.
Thank you, my Lord.
Right. Yeah, so we also have what they call the address, the final address. And this happens at the end of the trial. So after the evidence closes, lawyers or counsel will deliver the closing submission, which you call the address. Usually it's supposed to be written, and it will summarize the evidence. Each lawyer will summarize the evidence as they understand it. and then link the evidence to the issues adopted at the trial, and for the trial, and also apply the relevant law and request the court to give a judgment which favors his or her side of the case. So the structure will be, you have introduction, you talk about like the substance of the pleadings, you talk about the summary of the evidence, you may want to evaluate the evidence with respect to even like the credibility of some of the witnesses and so on. And then you make your legal arguments, and then the relief that you are seeking. So basically, that is what the address will cover. Yes, so we finish discussion of the trial. I will give I'll give 5 minutes break, and then we come and discuss judgment and then enforcement of judgment.